This courtroom clash exposes a shocking twist. A tenant fights confusion, unpaid utilities, and a dismissed eviction, while lawyers battle over missing funds and broken procedures.
Saying our case filed before the circuit court was filed on July 9th. They had jurisdiction of that breach of lease case. Part of the breach of lease case was that the landlord did not make necessary repairs for the health and safety of all those who were benefited by the lease. We notified them in that case that we would withhold, that they had been requested to make the repairs. They had declined since 2023. We had to make them for the coming winter for the horses and the people that were there. We notified them in August that they paid the rent in July. We notified them in August that we were going to withhold rent and make the necessary repairs themselves, mitigating, trying to correct the problem. They filed their summary judgment here in this court, which I agree, under a summary judgment, a trust fund would be set up. When they filed on October 20th, this was after months of making repairs.
Stop.
That's when this court got
Getting things confused.
Pardon?
Getting things confused with what I'm saying and with what you're trying to argue.
Mm-hmm.
I get with reference to any escrow order that the court initiates.
We asked for that.
It's what you did before that, Ms. Tobe, that I see as being problematic. You are acting as an attorney, and I'm just going to say this again, and you take into your possession client funds and then disperse them. So I'm going to put it in the most general sense I can. That has to be done in a particular way with certain accounting that comes with that and certain accounting that must then be reported. What is, well, I'm not going to say it's clear to me because I will say I have very serious concerns as to whether or not that happens or happened. Which, Ms. Toe, may, I'm not saying it will, may subject you to certain liabilities, potentially with the state bar.
That would be because of the circuit court case.
So I'll be honest with you. I'm not the one that you're going to have to explain it to. I mean, but I'm doing my best to say that on the face of what I'm seeing, you may be in jeopardy of some adverse consequences because of what's occurred. That's what I'm saying. What I'm also saying, it's troublesome from the court's perspective because
In this intense courtroom scene, a tenant stands confused as a non-payment eviction case is suddenly dismissed. She insists her rent is fully paid, yet management claims violations from a previous agreement. The judge suggests she seek legal help as the issue shifts to another pending case. Meanwhile, the court moves on to a complex dispute involving withheld rent, repair costs, escrow accounts, and accusations of improper fund handling. Attorneys argue over accounting records, trust rules, and jurisdiction between courts. The judge grows frustrated, warning counsel about serious legal consequences.
when you refer to you and your clients and certain things that have been done, and this is what happened, and I hate bringing up other cases with reference to present cases, but you keep referring to we in terms of your clients and you acting. Sometimes that is absolutely appropriate, and I don't just, it just is. It's just language. Part of the court's hesitation when you are saying it that way is that, and again, I'm saying this and I'm not making a finding, but if you were operating, I'm going to put it in form of a hypothetical, and I hope you can follow it. If your clients were following your advice to place the monies with you and then pay the money out, where that may be in violation of the plain language of the lease, right? They may have a claim, whether they choose to pursue it or not, as to you.
I understand what you're saying.
And so that's a problem for the case proceeding, because you can't be, you're representing them, but as to the position that they in the business should take, on the face of it, when I look at it, you have a conflict in terms of that.
Okay.
And outside of the fact of the first thing that I said, where you might be in violation, and I'm not saying you are, and I hate even making the accusation, of ethical rules that would apply to attorneys taking clients' money into trust.
I understand.
And again, I will give this blanket statement. I am not saying that, making any accusation. I'm not making any finding. I'm not saying any of that. I'm not saying, even to a great extent, my analysis, if I were to come down to the end of it, is correct. All I'm saying is that's what I see on the surface.
And your statement that you said was that if I, as their attorney, gave them advice to do what your hypothetical is suggesting, in this situation, the client asked me to handle, because of the lease, the violations of the lease and the threats that the fixing housing made before they filed this action, when we had to file the action in circuit court. Because of the threats, she wanted to have, my client wanted to have everything I's dotted, T's crossed, so that he would not be able to claim that she had not done what tenants are allowed to do which is if the landlord does not make necessary repairs, which are the terms of the lease, the tenant is allowed to withhold rent, take on the repairs themselves to make the place safe for their boarders and their horses.
What's the operative word you're using in that whole statement?
Pardon me?
What's the operative word you're using in that whole statement?
The operative word is,
Assuming you're correct on the law, which is a little bit iffy, but that the tenant may.
she asked me to make sure that he wouldn't be able to proceed on his threats. And I agreed to just oversee the,
No, you did more than just oversee.
well,
That's the problem.
and Your Honor, what in this situation, we're here before you. We requested at our last hearing for you to set up an escrow account, a trust fund with the court to accept rent going forward.
So I understand that. I know what I did.
Mhm. That's what we're here to move forward with. Are you not going to allow me to represent my clients going forward?
Ma'am, I've not had a motion to force an attorney's withdrawal in this case. If I make that decision, then I certainly can make that decision on my own motion, but I don't have enough before me that I would feel comfortable making that decision. It is a monumental decision if a court directs that to happen. I will say, Ms. Toe, I'm concerned as to whether or not that's where we end up.
That will, excuse me, I didn't hear.
I'm concerned that that's where we may end up.
I share that concern. I would like to know how you would like us to.
Well, I'm okay. So here's what I'm going to do, folks. And I really don't like delaying things. I like to try to keep things moving along. But Ms. Toe, because of the things that I've said, and I think you need to take what I'm indicating to you very seriously. Because there's no reason for me to, I really don't have a dog in that fight. There's no reason for me to say it other than the fact that you're facing jeopardy on a number of different levels. And so I'm going to do this. And I realize that it delays plaintiff, but I think the court is compelled to do this. I'm going to adjourn 1 week to the 21st at 3 p.m. And the basis upon which I'm adjourning is I think, Ms. Tope, you need to get the advice of counsel as to how you should move forward and if you should move forward.
Got that.
I also think, although I'm not ordering the defendants to do it, because I can't do that. I might suggest to you that if you've listened to what I've said today, if you believe in your interest to seek the advice of other counsel as to how you should proceed, I'm also giving that week for you that opportunity, should you so choose to do so, for you to do that. I'm not advocating for or against that. I'm just saying I'm giving you the opportunity so that you can make that decision based upon what the court has said. Okay? Anything else?
As I said at our hearing on last Friday, I am leaving, I'm scheduled to leave town for Thanksgiving vacation on the 20th.
Ms. Tope, I know, but
Okay,
I don't know what,
can I appear by Zoom?
you can submit the paperwork. I don't know if I'm going to allow it or not. I'm not answering that right now. I mean, because I don't know on what, quite frankly, from week to week with this case, I'm not sure on which capacity you're going to be appearing. So you can submit the paperwork and then do that. I'll leave it there. I mean, I have a lot of concerns here, folks. I just do. Anything else from the plaintiff?
Your Honor, just so it's on the record, the court doesn't need to untangle the mess with Ms. Tope's accounting. But as the court correctly stated last Friday, the lease language is non-conditional. Tenants are required to pay base rent of $5,500 per month without any deduction or set off whatsoever. There's no factual dispute that tenants have withheld rent. They admit it. And longstanding Michigan case law in the commercial context, tenants' duty to pay rent is independent of landlord's alleged covenants to repair.
Okay. So what do you want me to do with that?
Say, to avoid untangling that mess,
It's
clear.
No, but here's the thing. And there are certain, and I get what you're indicating, but I'm in a different boat. Understanding what you're saying is if a tenant recognizing their covenant to pay simply withheld the rent to try to get the landlord to do something. That's a different posture. Maybe they can do that. Maybe there might be a breach of contract in that regard, whatever. In theory, that wouldn't be allowed either, right? But we have another problem here because not only was that part done, but as I'm to understand, then those funds were then dispersed elsewhere. That creates a whole different ballgame. It creates a whole different ballgame, particularly where you're claiming a breach as to who did it. Right?
Yes.
And
That's right.
So while I recognize and understand what you're saying,
Your Honor,
it's all a mess, and they're sort of a mess on both sides. Less of a mess over here, more of a mess over here. I gotta try to clear that mess before I can even begin to deal with that. I've always wanted to use mess as a legal term. Go ahead.
It may be a term of art. I would just say it's the mess that's being caused by tenants, and they're responsible for the actions of their agent, is causing my client prejudice where he's not getting paid any rent, and tenants are operating their business on my client's property rent-free. So my client is the one who's being prejudiced by the mess.
And counsel, I'm well aware of that, which is why I'm trying to at least make some decisions, understanding the other action that was going on, but make the decisions within the confines of this month, which is why I'm not moving beyond. I realize that there is prejudice to your client, at least in terms of the funds being there. As I'm sure you understand the other issues over here, I've got to deal with, because I think unless they're cleared up, it's going to be even more prejudice to your client because you're going to be Don Quixote in terms of who you're trying to argue against.
Understood.
And that has to be solved. That's also why, despite Miss Tope's travel plans, I'm not going to my next date of December 5th.
Okay.
Because I don't know that come the 21st we'll resolve anything. But I got to give that opportunity over here. I have to allow that to occur, I think, in fairness and just to make sure that the proceedings are what they are.
Understood, Your Honor.
Can we address the order that you gave to set up an escrow account and how much should be put in it? Because the plaintiff in this case was paid $3,600 and some dollars for the rent on November 1st. Are they to put that into the court-ordered escrow account?
What I ordered at the last hearing on the 7th,
Mhm.
the monthly rent is $5,500,
Yes.
correct?
Correct.
What I ordered was that $4,125 was to be placed in escrow by the tenant.
By today,
Yes.
right? Is that
And $5,500 going forward. Pardon?
Is that the November 1st rent payment or?
I prorated November.
Okay,
That's how I get 4125.
okay. So the check that they got for 3,000 some hundred needs to be put into escrow.
So where's the 3,000 come from?
November rent, and the only amount that was withheld for necessary repairs was taken out of that. That is, my accounting is, I beg to tell you, it's not a mess. The accounting is very clear, and the exhibits for every invoice that was paid is very clear.
Okay. So the last time we were here, and I can't recall independently what the amount of the check was. Did you receive that check?
Your Honor, yes, we received it yesterday. And we sent a reservation of rights letter to.
Okay. So that was for how much?
$35.08
Oh, for Pete's sakes.
It was sent on November 1st before you made your order to prorate. So we are prepared to make the difference.
Did